The pro-life debate returned yesterday to the Supreme Court. The justices heard arguments on whether the FDA should reinstate safety regulations on an abortion pill, with those cautions lifted after the agency made mifepristone available by mail. CBN medical reporter Lori Johnson has the details.
Hundreds of demonstrators gathered in front of the U.S. Supreme Court building, eager to make their voices heard, some hoping the justices rule against those who want to limit access to the abortion pill.
Their argument that, it's dangerous for the woman is absolutely incorrect scientifically.
Others think mifepristone, now used in 2/3 of all abortions, is unsafe and too widely available.
The clinic had told me they pressured chemical abortion and said that it would be easier than surgical abortion, but that wasn't true. That was a lie.
Outside the Supreme Court, CBN's Tara Mergener points to the last time we saw similar demonstrations.
This case comes less than 2 years after the court relinquished federal oversight of abortion rights, leaving the issue to individual states and their legislatures.
Inside the courthouse, while the FDA argues removing doctors' visits to get the abortion pill isn't dangerous, Justice Alito questioned the safety of removing all three.
Isn't that obvious that three things that may be innocuous or not excessively dangerous, if engaged in by themselves, may become very dangerous when they're all done together? And why shouldn't the FDA have addressed that?
The attorney for a group of pro-life doctors pointed out that the FDA itself admitted the drugs harm a significant number of women.
The FDA concedes that between 2.9 and 4.6% of women will end up in the emergency room. The FDA acknowledges that women are even more likely to need surgical intervention and other medical care without an in-person visit.
Even so, some justices appeared to give the FDA more weight when it comes to certain decisions.
The reality is, even if there is some increase in emergency room visits, the question of when that rises to a sufficient safety risk is up to the FDA, correct?
The attorney countered that the FDA behaved recklessly by removing safeguards, which can put doctors in the position of unwillingly taking part in abortions.
FDA's outsourcing of abortion drug harm to respondent doctors forces them to choose between helping a woman with a life-threatening condition and violating their conscience.
As to the doctor's conscience concerns, Justice Jackson questioned whether that would warrant limiting the availability of mifepristone.
Do we have to also entertain your argument that no one else in the world can have this drug, or no one else in America should have this drug in order to protect your clients?
While the justices did seem to consider safety issues associated with mifepristone, many comments focused on the issue of standing, that is, whether the pro-life doctors have been or will be sufficiently harmed. The High Court is expected to announce its decision in June. Lori Johnson, CBN News.
All right, thank you, Lori, and all eyes will be watching. Gordon?
They will. I commented yesterday, we need to be concerned about the health of women. If this drug leads to 1 in 20 being admitted to an emergency room, that obviously raises safety concerns. But after yesterday's oral argument, the Supreme Court has sort of two easy outs here where they don't have to decide the case on the merits. Was it proper for the FDA to do this? They can say, well, you don't have standing to bring this case, and that would be, I guess, the easiest way. The second is it's not up to the courts to second-guess the FDA. There's the legislative branch and the administration branch that ought to swing into action if the FDA does that kind of thing. And is it up to the court system, particularly when they're not dealing with an injured patient? So this is very complicated legal arguments. There's obviously politics involved. We'll see the decision in June.